Thus far, we have completed with what is offer, what are the essentials of offer, and what are the types of offer. Today, we'll be beginning with the next part of the chapter called as acceptance. Let's see what does the Act define acceptance as. According to Section 2B of the Indian Contract Act, acceptance is defined as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes promise. So from the beginning, we have learned about what is offer, what is proposal, or what is contract, correct? Now here we are today going to learn about acceptance. So the Act defines acceptance is when what? The person to whom the offer is made accepts to it, or agrees to it, or gives his assent thereto. So right when he accepts the proposal or accepts the offer, a proposal when accepted becomes what? Promise. Okay? An offer is made by one party to another party. When the other party to whom the offer is made accepts the offer, it becomes acceptance or gives his assent thereto. So once the offer is accepted by the other party, it turns into a promise. Let's see who can accept the offer. The acceptance must be from the person to whom the offer is made. The offer cannot be accepted by the another person without the consent of the making it. Example, if the offer is made by X to Y, the acceptance by Z would be inoperative. Now in this case, we are studying who can accept an offer. Only to whom the offer is made, only that party has the right to accept that offer. If there's anybody else who wants to accept the offer, there has to be a prior communication with the offerer to the offeree. Got it? So who can accept the offer? Only to the person to whom the offer is made or the proposal is made, only that person or that party can accept the offer. Any other person accepting the offer is inoperative in the eyes of law. Let's look at the few of the essentials of a valid acceptance. Remember, we looked at the essentials of a valid offer. Today, we'll be looking at a valid acceptance. For an acceptance to be valid, the first essential is it must be communicated to the offerer. So whoever has given you an offer or proposed you or given a proposal in front of you, to that person or to that party, the acceptance or the agreement must be communicated. The offeree should signify his intention to accept the offer. It must be communicated through some means. Okay. Now, if the offerer is telling, if you accept my proposal or if you accept my offer, you have to give your acceptance in a written format, or you have to give an acceptance by making a down payment for the asset, etc. Now, if he is laying down some certain conditions or certain means of acceptance, then the offeree to whom the offer is made should accept that offer on those terms and conditions. Okay. Now, let's look at this case. It's Brogden versus Metropolitan Railway Company. Let's see what's the case about. Now, there are two parties to the case. Brogden is a company or is a people who are going to supply coal to whom? To the railway company. Two parties. Brogden is one person or a group of people and a Metropolitan Railway Company. Now, let's look at the case. The facts of the case are that Brogden, remember, were suppliers of coal to the defendant. Who is the defendant in this case here? The railway company. Now, this supplying of coal by Brogden to the railway company was happening for couple of years. Okay, for couple of years, the supplying of coal was continuing on and on. So there came a time that even though all the supplying of coal was happening on informal basis, so there was no written contract. It was just an oral agreement between Brockton and the railway company for the supplying of coal. There was no written contract as such. So, however, over the years passed by, both the parties, that is the Brogden and the railway company, decided to have a formal contract. Why? Because to the best of their business dealings, it is better to have a contract between both the parties. Hope you understood the facts. Moving on, the railway company then took the first step in making the contract or drafting a contract, and then for a verification or for a reading, they sent it to Mr. Brogden. So Mr. Brogden made some minor amendments or whatever changes it has to be made in the contract. Maybe it can be the price of the coal or how many tons of coal to be sent, etc. All those changes he made it and filled in all the some of the blanks that were left. And then after making all these amendments or changes in the document of contract, he sent it back to the railway company. Once the railway company received the altered contract or certain changes made to the contract, they never communicated their acceptance. Okay, they just took that document or that contract and just filed it in their documents. That's it. They didn't communicate their acceptance. After this, their business dealings, that is ordering for coal and Brogden supplying of coal, this business dealings continued afterwards. Okay, so Brogden continued to supply coal to the railway company. The point to be noted here is, after the contract was amended or altered, the railway company did not communicate their acceptance. Is that clear to you? These are the facts of case. Brogden and railway company. Let's look at what was the issue about this case. When the dispute arose, the issue in this case was whether there was a contract between Brogden and the railway company, and if the written agreement they both had, that is both the parties had, was valid in the eyes of law. So over the years, when this business was continuing, there came a dispute between the Brockton company and the railway company, maybe regarding the price of the coal, regarding the quantity of the coal, etc. When this dispute arose, they were in a dilemma that whether the contract that they framed couple of years back or couple of months back, whether this contract is valid in the eyes of law. And remember, it's a written contract this time, not just an oral agreement way back, but currently it is a written agreement. So let's see what the court says. The House of the Lords, that means the court or the judge, said that there was a valid contract. Notice what he says, there was a valid contract between the suppliers Brogden and the railway company. The draft contract that was amended constituted a counteroffer. Why does it constitute a counteroffer? Remember, who drafted the contract first? It was the railway company. Then the railway company sent the contract to Mr. Brogden, the supplier of coal. Now he made the necessary changes or amendments. You remember that word amendments means? He made certain alterations, etc. That means it was a counter offer. So once he made the change and he brought back to the railway company, which was accepted by the conduct of the parties. Notice here this word in the second paragraph, which I have underlined, they never communicated their acceptance. The second line, third line, during this time business deals continued. Notice that word, business deals continued. That means they did not convey or communicate their acceptance by words, but by their conduct, okay, by their behavior or by their business dealings, it was accounted to be acceptance. The prices agreed in the draft contract were paid and coal was delivered. Understood? The railway company never communicated their acceptance in terms of oral agreement or through words. They just kept the agreement with them or the contract with them and continued the business deals based on the changes made in the contract or based on the prices agreed upon in the contract. Although there had been no communication of acceptance, performing the contract without any objections was sufficient to say that there was a valid contract in the eyes of law. Is that clear? Now, this was the case of Brogden versus Metropolitan Railway Company. What is the essential here? It must be communicated the offer. However, in this particular case, the conduct of the other party would affect as acceptance to the offer. If you remember another case we discussed just previous classes, Carlyle versus Carbolic Smoke Ball Limited Company. There also, if you can see, the court had told Mrs. Carlyle never communicated to us her acceptance of the offer. You remember the statement she company had told in argument in the court. But what did the court tell? When there are certain conditions or certain laid down amendments in the contract or in the offer, when the other party is performing that contract, okay, is according to the conditions, if she's performing or taken that medicine for the consumption, it is understood that she has accepted the offer. She did not have to communicate her acceptance to the Carbolic company. Same case is Brogden versus Railway Company. Even though Railway Company orally did not tell Brogden, the suppliers of coal, about their acceptance, but by their conduct, it was accounted to acceptance in the eyes of law. Hope you have understood this first case for the first essential of a valid acceptance. Moving on, the second point, it must be in response to the offer. Can there be an acceptance without offer? Definitely not. Offer, only after an offer is given or a proposal is made, acceptance can be given. So there can be no acceptance without offer. Acceptance must always follow the offer. Third essential, it must be made within reasonable time. A valid acceptance will be made within the reasonable time allowed by the offerer. So usually when a person or when a party is making an offer to another party, it is always he mentions, no, convey your acceptance. Whether you agree to this proposal or not, please convey it within a week. Or if it may be business dealings within a month, etc. Right? I am giving a reasonable time frame for you to accept my offer. So the other party must accept within a reasonable time. He cannot take his own time and to convey his acceptance or his non-acceptance. Whatever it is, make sure he is conveying it within reasonable time. So that is your third essential of acceptance. Point 4. It must be made before the offer lapses or revoked. Acceptance must be given when the offer is in force, that is before it lapses. Just before we had worked on revocation of offer, correct? Now same here, this happens. We studied various conditions when an offer can be revoked. It can be revoked by a counter offer. It can be just a disagreement or non-acceptance of the offeree, or either it can be by death, insanity, or by illegality, etc. We looked at various conditions, right? Now, when should the acceptance be made? This acceptance must be made before the offer lapses or before it can be revoked. Now, if the offerer has given certain time period for the other party to convey his acceptance, after the time period is completed or after the time period lapses, if the other party is giving acceptance, then it is not valid in the eyes of law. Acceptance must be given when the offer is in full force. That means when the offer is open to agreement, then he must be accept to it, or then he must be able to agree to the terms and conditions of the offer. Point 5. It cannot be made through silence. So silence is not a mode of acceptance. No contract is formed if the offeree remains silent and does nothing to show that he has accepted the offer. This is a very important point. Now, many of the parties in the contract, they just remain silent. either, see, when a party is making you an offer, right, giving you a proposal, you must either say yes, I accept to the offer, or no, I do not accept to this offer. Either two, yes or no. But if the offeree is not at all conveying and is just remaining silent, then acceptance is not regarded as silence. Okay, silence cannot be considered as acceptance. If you are agreeing or accepting a particular offer, you have to tell it in a certain mode. If you're not telling, if you're keeping silent as an offeree, then that will not be accounted as acceptance. No contract is formed if the offeree remains silent and does nothing to show that he has accepted the offer. So some cases what happens, the offeree might not tell orally, I agree to it, I accept to it, but by his behavior or by his conduct, he will convey to the other party that he has accepted the offer. Just in the case what we studied today, Brogden versus Railway Company, they did not communicate it orally, but by their conduct and business dealings, it was understood by Brogden that the Metropolitan company or railway company has agreed to the offer or accepted the offer or proposal. So acceptance cannot be made through silence. Either it has to be expressed in words or either it has to be implied by the behavior of the other party or conduct of the other party. Moving on to the sixth one, sixth essential, it must be in the prescribed manner or a reasonable mode. It must be made in a prescribed manner or a reasonable mode. Where the offerer prescribes mode of acceptance, then the acceptor should adopt the same mode, else it can be made in a reasonable mode. Now if I have to convey my acceptance, how should I convey? It must be in a prescribed manner. When does this word prescribed manner comes up is when the offerer itself is telling, adding a condition. If you're agreeing to my offer or accepting to my offer, I want you to write in a letter or make a agreement or make a statement or a written document and send it to me by a week. So this is my condition. This is my prescribed manner. I want a written acceptance from the offeree within this time period, maybe a week or a 2 week. Okay, if the offerer does not say any conditions, okay, within a week or written, oral, does not prescribe anything, but then in such cases, in a reasonable mode is what? You just convey to him orally, okay, I accept the offer. Or if you're not even able to orally express it, by your behavior or by your conduct, you must be able to convey to the offerer that you have accepted the offer or you have accepted the contract or proposal. Is that clear? Where the offerer prescribes a mode of acceptance, if he is prescribed, then you have to accept in that prescribed mode only. Anything apart from the prescribed mode you are doing, then it is not legal. I mean to say it is not termed as a valid acceptance. Only when no prescription or no prescribed manner is provided, then it is up to the acceptor or it is up to the offeree to convey his acceptance in a reasonable mode. So these are the 6 points that we have studied today. We learned about what is acceptance according to the Indian Contract Act, who can accept the offer, essentials of valid acceptance. First one, it must be communicated to the offerer, either in case of oral, either in case of conduct, by conduct or by behavior. We looked at the case Brockton versus Metropolitan Railway Company case. Second essential, it must be in response to the offer because acceptance should always follow the offer. Third, it must be made within a reasonable time. You cannot take your own time to convey your acceptance or your non-acceptance. It must be made within a reasonable time. Number 4, it must be made before the offer lapses or revoked. So when the acceptance is given or must be given whenever the offer is still active or still is in force. Number 5, it cannot be made through silence. So silence is definitely not a mode of acceptance in the eyes of law. Either you need to express it orally, or either you need to conduct it by your conduct and by your behavior. You must convey to the offerer. The 6th point, it must be in the prescribed manner or a reasonable mode. So whatever mode is prescribed, you accept in the same terms, or if nothing is prescribed, then you accept it in the reasonable mode. So these are the 6 points we have studied today. Next.